Good evening, all of you. Thank you very much for joining. Welcome to this seventh episode of the PhD mentoring session. So today we have Dr. Abhay Singh Thakur. So he'll be talking about the doing PhD in maritime law. So earlier we have done, sessions on how to choosing topic, chapterizations, right? Different like publication part that we did. So we thought of let me plan this, a particular topic doing PhD because I would say maritime is one of the booming area nowadays. Maritime, marine space law, sports law, uh, technology, IPS. Like these are the I would say top five, one of the top five area nowadays. So I thought requested Dr. Abhay Singh to share his experience and the various topics. What are the available on which topic participant prospective scholar should do PhD because many are clueless like which topic we should take in our PhD research work. So let me introduce Dr. Abhay Singh. So Dr. Abhay Singh Thakur is a faculty at Gujarat Maritime University at Gandhinagar. He also holds a position of director in charge of the School of Maritime Law, Policy and Administration, and a member of the Board of Management and serves as a center head of Center for Maritime Environmental Law at the university. He brings him with over decades of experience that spans over academia and the maritime industry. His core area of expertise includes shipping laws, regulations, maritime environment law, and the law of international carriage. Dr. Thakur has presented research in prestigious national and international platforms. Notable among the are the 46th Conference on Ocean Law and Policy organized by Ankara University at collaboration with US Naval War College, the International Association of Maritime Economics Conference in Rotterdam, and the International Conference on Advanced Intelligent Maritime Safety and Technology at Malaysia. His academic contributions have been recognized with numerous publications in Scopus, Web of Science, and UGC Index International Journal. In academics of domain expertise is regularly invited by various institutions like Gujarat National Law University, Indian Maritime University, Karnavati University, IFM Law College, CARE VMLS at Chennai, and Tamil Nadu Dr. Ambedkar Law University, which he delivers key and contemporary maritime issues. So he holds a doctorate and a PhD in Gujarat National Law University and engaged in multidisciplinary research focusing on maritime environment law and then is done LLM from the NUJS Kolkata. And further, he is doing research, various research in various aspects of maritime and environment law. So with this, on behalf of Law Teachers India, we welcome Dr. Abhay Singh and then share our experience and what way we should do, participants should do PhD in maritime law. Over to you.
Uh, Thank you so much, Kalpesh sir, for having me. So I can see that there are only, 4 or 5 people who are there in this particular, uh, you know, uh, meeting that we are having right now. Anyways, so the area actually itself is a very niche area. So internationally, we don't have just very few people joining in here, but internationally also, in maritime law, there is a people crunch. It's a place where much people are not there. It's a place where researchers are not there. And it's a place where literature is not there. A very limited literature access is available. So it's a area where we have the issue of uh, less number of indulgence. So there are a lot of misconceptions associated with maritime. This is something that I wanted to talk on. This is one issue. But before I move along to the understanding the concept of maritime law, so I'll talk on why there are very less people all across available in the shipping area or the shipping or the maritime domain in general. So we people in general are not associated with oceans. We don't see oceans every day. We do see glimpses of it in forms of containers on board of a truck somewhere roaming around. But we never stop and think about where did that container came from. So we have billions of containers roaming the seas, and everything that we use on a daily basis have been on board of a vessel. If it has not been for the logistic industry, particularly for the maritime industry, we will run out of commodities. We will run out of the basic things that we take for granted. Your cars, right? Your very cars, your TV, your electronic gadgets, everything will disappear. Your Hyundai and your Toyota vehicles and Ford and whatnot, they are not made in India. They are assembled in India. They're coming from somewhere. You're not creating these things in home. So shipping is something which is the reason why you're able to get all these things. But still people don't think about it. People don't research on it. And probably the reason is because they don't see it. They don't, since they don't see it on every day on the news channels or otherwise, we don't focus. We ignore it. And this issue is actually called as sea blindness because we don't see it. We don't understand the importance of it. We don't understand the cruciality of it. 95% of India's international trade actually occurs through ships. So 95%, it's absolutely everything. The rest 5% is a mixture of aviation and road and rail transportation, with majority coming through aviation. But you have shipping, which is responsible for 95%. That's a huge, it's almost everything that we have in the international logistics system. So, still, irrespective of that, we don't look into ships, we don't look into oceans, we don't look into marine biodiversity. Law colleges are no help. No law college teaches maritime law, unfortunately. And whatever teaches maritime law, it teaches in the sense of law of the seas. It will be an associated one module somewhere in the bottom of international law course. They will teach you a little bit about law of the seas, and that's it. And many times when we talk to anybody who's anybody in law, and when we talk about or discuss about them with them on maritime law, automatically they start talking about delimitation issues, maritime biodiversity and fishing and whatnot. So that is all law of the seas. Law of the seas is one small subset of maritime law. It's not maritime law in itself. Hence, coming to this particular heading, understanding maritime law, law of the seas, shipping law, and admiralty law. So first of all, we'll move along to the misconception. The misconception created by the online platforms, particularly ChatGPT. So we have if you ask ChatGPT, if you do right now and you ask ChatGPT, tell me the meaning of maritime law, it will tell you that maritime law, also known as the admiralty law, governs blah, blah, blah. It will tell you that it governs contract and commerce and maritime injuries, environment and insurance. You try to regenerate the answer, it will again talk about maritime law, how it covers a range of issues, water navigation, and contract and issues of unclause. So it's giving you a very mixed up answer. If you look into it and thereafter, if you even ask what is the difference between admiralty law and maritime law, earlier it was mentioning that admiralty law and maritime law is the same thing. Now it will give you a difference also. It is giving over here a difference between the maritime law and the admiralty law. So the reliance on, so that's not just ChatGPT talking. I'll take you further. So you have to understand, when we talk about maritime law, we have two subsets. We have a public international law area, we have a private international law area. If you look into here, again, this is Elsevier. If you are a PhD researcher, if you are somebody who is interested or who do frequent research, you obviously will know what is Science Direct, what is Elsevier. So this is an Elsevier database. Here also you can see maritime law. It says that a body of private law governing navigation and ship in each country, private law. Now here it is associating private law with maritime law. So it is saying that private law is maritime law. Private law primarily means the private international law, which is the issue between two people or mercantile law largely. And just next to it also, you can see just next to it, the different article is projecting you a definition of maritime law, where it is saying that maritime law example is distinguishing the territorial seas and the international water. That is law of the seas, right? You have the territorial zone, the contiguous zone and whatnot, and territorial contiguous zones, high seas. So that's primarily is law of the seas. So here, over here, one paper is telling you, one research paper is telling you that maritime law is law of the seas. The other paper is telling you that maritime law is contract law. Similarly, if you move forward also, you'll find in different papers, different issues associated with it. Now, to clarify the concept, you have to understand that maritime law is actually an umbrella term. It is not private maritime law, it is not public maritime. You have to understand there are two different things. There are two different subsets of maritime law also. You have the public maritime law, which largely associated with law of the seas. And when I talk about public maritime law, it is similar when we are talking about public international law, where the parties associated are countries, states. So in law of the seas, you have the nations which are associated, and or states and international organizations, right? These are the only parties. So in case of any issues regarding the law of the seas or maritime delimitation, particularly measuring the inland waters, territorial sea, contiguous zones, high seas, you have the dispute between two countries. So if there is a dispute between two countries, you will go where? To the international courts. You will go either to the International Court of Justice, or you will go to the ITLAS, the International Tribunal of Law of the Seas. So you have these distinctions. You have law of the seas, international law, which is a public subset of international law, issues between two countries regarding maritime delimitation, maritime resources, or fisheries, or what biodiversity, and the cause of action will be in ITLAS or ICJ. And then you have the other area, very different area, which is the private maritime law, which is private international part of maritime law, which is largely called as shipping laws. And when we talk about shipping laws, we are talking about the contract issues. We are talking about shipping issues, that when there is a problem between two entities which are companies, business to business or business to government. If there is a private entity involved, then what is the liability? If the cargo is coming from US, it is coming to Mundra, from New York port to Mundra port. Two companies are involved. One company is shipping some 100 metric tons of coal from Sydney, and they are bringing it to Reliance port at Jamnagar. If that happens, when that happens, you have two companies, one company in India, one company in Australia, trying to have a contractual dealing. But in case some issue happens with the vessel at sea, some, let's say, uh, injury on board of the vessel, or let's say some collision of the vessel occurs where the cargo is lost, where will these companies go to file a case? Where will the litigation happen? Whether it will happen in Australia, whether it will happen in India, or do you go to ITLAS and ICJ in that regard? Absolutely not. You cannot go to ICJ or ITLAS in this regard because you're a private company. ITLAS and ICJ will deal with public international law matters. So when you are a private entity, where do you go? You go to the domestic courts. Based on the principles of private international law, you either go to the courts in Australia or you have the jurisdiction in the courts in India. Now, all the contracts, all the shipping contracts that you'll find will have the clauses of jurisdiction and arbitration. So the contract itself makes it very clear that which law will be applicable and which court have the jurisdiction over the matter. Same goes with the arbitration. You'll probably have a separate arbitration agreement or alternate dispute resolution agreement primarily, which will tell you about the mediation, the process, the conciliation process, and the arbitration process. And what will be the seat of arbitration? What will be the venue of arbitration? So those definitions will be affixed. So that is something which happens in private international law, private shipping law, which is primarily the international, it can be institutional arbitration, it can be ad hoc arbitration, right? It can be a fast track arbitration also. It depends upon where you're moving forward. So idea is that you have the law of the sea, which is a different area altogether, different side altogether, which is public international law. Two countries have an issue, or a country or an international organization has an issue. However, your shipping law or international shipping law is parallel. It is very different. The cause of action is the local courts, the municipal courts, or international arbitration. It can be institutional arbitration. You can go to Mumbai International Arbitration Center. You can go to Gujarat International Maritime Arbitration Center, GMAC. You can go to Hyderabad International Arbitration Center, Delhi International Arbitration Center if you want to have the matter in India. Or you can go to Singapore, SIAC, right? Singapore International Commercial Arbitration Center. You can go to Hong Kong Arbitration Center and whatnot. So you have that also as a area where you can move the issues from. So you actually have a lot of researchers right now working in law of the seas. A number of people are working on law of the seas, either biodiversity, either fisheries issues, right, or delimitation issue, Sri Lanka India issue, India Pakistan issue, so or India Myanmar Bangladesh dispute. There are a lot of people working on law of the seas. However, when you talk about shipping laws, there are very few people who are actually shown interest in the private aspect of shipping law, which is very crucial, largely ignored as well. Anyways, so oceans are very critical for us in journal. This is something which we don't realize, because in the schools also since childhood we have been taught that for the environment also it's trees which are the lungs of the world. They call Amazon as lungs at the world, Amazon forest. And they say that the majority of oxygen comes from trees. It's actually untrue. The majority of oxygen actually comes from oceans. You have a lot of seaweed, coral, which actually emits, provide oxygen and work as a carbon sink. The 80 to 90% of carbon is observed by oceans, not by trees. So that is something, this is a misinformation which our schools have been teaching us, that trees are the reason why we have oxygen. It's actually the oceans, which we are ignoring because we want to dump our garbage and all waste at ocean and kill the biodiversity. Oceans regulate oxygen. They provide oxygen. They regulate climate. Your winds, your monsoons are all regulated by oceans, because your movement of winds happens because of heating and cooling down of the seas. The wind momentum rushes from hot to cool, cool to hot. Like that, the wind direction comes, it changes. And with the wind, it carries your clouds, who does the rainfall and everything. So your oceans actually control not just your oxygen, they control your, they control the weather, they control resources, they control transportation, they control food. As major 17% of protein which humans consume comes from sea in form of fish. It's a very big provider of food as well, oceans. And security. Maritime security is something which is very crucial, very, very important nowadays with the rising conflict. Iran is Israel, US conflict. You have the Houthis in Yemen, that issue. You have the India-Pakistan issue. So see, don't think that India-Pakistan issue doesn't have a maritime implications. Due to India-Pakistan issues, India and Pakistan both has blocked a major chunk of Arabian Sea where logistics were happening. It is not happening there, and both of the countries are sustaining big economic loss because of that. So that is another problem. Maritime security plays a huge role in terms of finances, commerce, food, logistic as well. So that is again a big, big concern. Tourism also one of the major issues in maritime. So moving forward, if I talk about, see, I have already highlighted the difference in maritime law and law of the seas. Because maritime law, I've told you, is an umbrella term. It includes law of the seas, but law of the seas is not the entire maritime law. It is a small part of it. It's a very small part of it. Maritime law includes your shipping regulations as well. So there is a division between there is a division between shipping law, which is a private subset of maritime law. And admiralty law is also a private subset of maritime law, but there is a difference between shipping law and admiralty law as well. So we will talk about it later on. I'll come to that also. But right now, when we talk about shipping laws, we are primarily talking about cargo issues, movement of ships from one place to another, taking cargo on board. And this includes dangerous cargo also. You can carry dangerous cargo at sea as well. The condition is that you have to fulfill certain requirements in international law. You have MARPOL Annex 2 and Annex 3, which needs to be complied with. You have SOLAS Convention, which is the Safety of Life at Sea Convention. Safety Convention, you have to follow that. Marpol Convention is actually International Convention on marine pollution from commercial ships. So prevent pollution is Marpol. Annexure 2 and it has 6 annexures. Annexure 2 and Annexure 3 is on dangerous cargo. SOLAS Convention, Safety of Life at Sea on Dangerous Cargo. You have IMDG Code, which is the International Maritime Dangerous Goods Code. You have IBC, not the bankruptcy code, but International Dangerous Bulk Carriage Code. You have IGC, which is for Gas Carriage Code. So you have these all laws for dangerous cargo, which are also a subset of shipping law. You have marine insurance, which is again another issue, another subset of maritime law. Insurance is very critical. Insurance can be of hull and machinery, which is hull and machinery insurance is actually compulsory. Anyways, we'll come to insurance later on. So marine insurance also falls under shipping laws. Arrest and detention of the vessel is actually falling under Admiralty law. Arrest and detention is under Admiralty law. Pollution goes under shipping law. Then you have the issue of maritime dispute resolution also, which is again a subset of shipping laws, if you talk about maritime dispute resolution. Anyways, moving forward, so just highlighting the major areas. Maritime law includes law of the seas, admiralty law, maritime contracts and insurance, maritime labor law, marine environment, maritime dispute resolution, port and infrastructure legislature, and cargo claims. Passenger carriage also. I think I've missed the passenger carriage one here. But carriage claims falls. It will incorporate passenger claims as well. If I talk about the initial one, law of the seas. Law of the seas has many issues highlighted under the UNCLOS. But UNCLOS is not the only agreement you look into or only convention that you look into when we talk about law of the seas. There are a lot of other agreements, subset of law of the sea, BBNJ. The High Seas Treaty, recent High Seas Treaty is one of them. You have many other FAO regulations. You have Port Major Agreement, which is one of them. You have the SUA Convention, which is the Unlawful Activity at Sea Convention. Again, a very important, crucial element of the law of the sea. Anyways, when we talk about law of the sea, we have certain very crucial topics nowadays where people are researching on. One of them is maritime delimitation. Although, if you give an overview of law of the sea and you see that, okay, maritime delimitation is fairly simple. You have the, inland waters, and then you have up to 12 nautical miles of territorial sea, then 24 contiguous zone, then 200 exclusive economic zone, and after that, high seas. That's, fairly what is written under UNCLOS, and it's very, very clear, and you don't have to think much about it. That's what majorly people think, but that's not true. Calculating a marine delimitation is a headache. It's a very, very, very big issue. We'll move along to it. I have kept in the last a few examples of research topics. Maritime delimitation is a very complex topic because, see, you can have a very well-defined territory, an Indian territory where land is defined, but then you'll have a small island just in front of it. Then what do you start? Where do you start your delimitation? Whether you started from the mainland or whether you started from the island, which is just in front of you. Whether the 200 delimitation starts from the island, which is some maybe 100 kilometers in front of your shore. So that is again an issue. There are certain islands if you read the UNCLOS, you'll find a definition of island, which is unclear. And it mentions that rocks you can include. There are certain formations which are just rocks. But what is a rock and what is the difference between a rock and an island? Nobody knows. Nobody has provided that. That is again a problem. Now, what if you build an artificial island in front of your land, in front of your territorial sea, some maybe 20 or 30 or 50 kilometers ahead, you build a artificial island. China is doing it. Abu Dhabi, Dubai is doing it, right? So whether that artificial construction give you a additional delimitation, it doesn't. It defines that 500 meters is the definition. Nonetheless, what about a situation where it is actually a rock, but then you have made so many major altifications that now it looks like an island, a huge island, and people are living there and you have governance over it. Does that make it a actual border, and from there you start your delimitation. So the international view on this is no, but you have China, which has actually claimed this kind of thing. There is an island known as Mischief Island. So if you just see Mischief Island in the South China Sea, you'll find the Chinese claim and how China validated its claim over the Mischief Islands and the surrounding areas, the nine dash line. Anyways, so the idea is that maritime delimitation, complex issue, not that simple. Freedom of navigation is another issue. So your law of the sea is very clear that you have the right of innocent passage. But then whether warship has the right of innocent passage, no definition, no clear vision. UNCLOS allow warship also to have an innocent passage. So but do they have to notify? UNCLOS is silent on that. So if a US warship enters India, can it just directly come to India without giving any information to India? UNCLOS is silent. US says it can. India says you cannot do that. US says it can. China says you cannot do that. So, but US is very clear on freedom of navigation. It says, as per UNCLOS, we can enter. Although US is not a party to UNCLOS, but still, they say that UNCLOS, we still follow UNCLOS and we take it as a customary principle. So we follow it. So UNCLOS becomes a customary principle for US when it wants it to be a customary principle. When it doesn't want to be a customary principle, they just simply mention that we are not a party to the UNCLOS, making it again a complex issue. Anyways, under the law of the sea, you also have marine resources, and marine resources also are of two different types. You have living, for example, you have sea weed biodiversity, you have fish, you have other organisms living at sea and ocean. And you have non-living resources, primarily oil and gas, and nodules. So initially, when we started the drilling activities, the main concentration was oil and gas, but later on, now the concentration has moved on to copper nodules, lead nodules, which are available at seabed, and extraction will assist in creating a lot of batteries, and so primarily lead batteries. That is the major function. There are very rare earth minerals which are available at sea, and mining of that is again underway. Anyways, MSR, marine scientific research, is another area, and as per UNCLOS, you cannot do MSR, marine scientific area, as certain protected areas, MPS, marine protected areas. You cannot do marine scientific research for commercial purposes. But companies are doing marine research in that area. Private companies which have a commercial end are doing research in the marine protected areas by giving a declaration that right now we are not doing research for profit purposes. Right now we're just doing research, that's all, with no declaration that maybe in future they will change their mind. They've already done research. They can definitely use it to explore and exploit that particular protected areas. Another issue under MSR. SUA convention, unlawful activities. So unlawful activities include piracy. It includes smuggling. It includes any kind of unlawful carriage, which can be of stowaway as well. Stowaway are illegal people on board. Anyways, so you have that area also under law of the sea, and then you have shipping law as a separate area, a private international law area. And when we talk about shipping law area, the main concentration, as I told you, is cargo carriage. In this particular slide, I had largely highlighted that what is the difference between your traditional viewpoint, traditional contract law, and shipping law. So many times in shipping law, your vicarious liability principle also gets defeated. And privity of contract, which is a very basic elementary principle of traditional customary law, also fails in shipping, particularly in case of bills of lading purchased through a third party. I will not dwell on this much because of the scarcity of time. I'll just move on to the next one. But if you're interested, this is actually a really interesting but confusing area. And this is primarily the foundation of maritime arbitration also. Cargo claims are the most common ones. And this is something which is a very, very interesting area, and not very much people are there available on this particular domain. So it's a very, very crucial and very interesting area to research upon. This marine contracts, maritime contracts and insurance is another area. So other than the cargo contracts or the contracts to carriage of goods by sea, there are contracts for towage and salvage. So your towage is towing the vessel from one place to another, right? You would have seen car being towed at the road, by different cranes and whatnot, right? So this is the same thing, but at sea. And there is a difference between towage and salvage. Towage is when you are just towing it for navigational purposes. So see, when a vessel comes inside of a port, it has to turn its engine off. So there they use a tugboat to tow the ship inside using the tugboat's navigation system. So that's primarily towage, just providing a facility. Salvage, on the other hand, is when the vessel is in danger. So salvage operations is provide to salvage and save the ship from a particular danger. So that's prime elementary difference between a towage contract and a salvage contract. You have to pay for that service. Towage will be cheaper. Salvage operations will be much more costly. Now, if you know about the Ever Given issue, there were three salvage vessels in the Ever Given, indulged in the Ever Given. One of them sank because it collided with the main vessel itself. So your salvage claims also are different types. And that again raises a very important question, that what is the liability of the evergreen vessel for the salvage, right? They have other liabilities of cargo claims and all. But what is the liability against the salver who lost his ship? So that is again an issue, right? So just giving you an idea about it. Do you have shipbuilding and ship repair contract? India used to be one of the biggest shipbuilders in the world, but then the policy framework was not friendly. So most of them went to Singapore and Dubai. And you don't have much shipbuilding in India now. Only two, three companies do that. And we are not able to compete with China and Japan and South Korea when we talk about shipbuilding. The government wants that to be fixed. The government is actually pushing and have released a lot of money to have shipbuilding in the country. But still, we have the shipbuilding companies which are suffering. There are multiple reasons for that. If somebody wants to ask a question later on, they can have it, they can ask. But due to lack of time, I'll just move along. Now, for these contracts, actually, BIMCO is an international organization, private international organization, composed of shipping companies, freight forwarders, custom house agents, lawyers. So they have joined together and they have formulated an organization known as BIMCO, Baltic International Maritime Council. The BIMCO organization actually creates standard form of contracts. So you can actually find free of cost charter party agreements, bills of lading, standard form of models, towage contracts, salvage contracts, and all the other contracts free of cost. You will find samples on the BIMCO website. You can right now also go to the BIMCO website and see all the charter party agreements and all the other type of agreements. So they are easily available. So this process actually mitigates the legal cost. But yes, with constant changes happening in the maritime regulation, they also become outdated and require constant change. Anyways, another area is maritime insurance, marine insurance, very crucial area. So you need to buy, when a vessel is moving forward, hull and machinery insurance is actually compulsory. You have to purchase hull. Every single ship has to purchase hull and machinery insurance, mandated under the SOLAS Convention. Cargo insurance compulsory. You should have it to reduce your economic burden, but it's not compulsory. Maritime labor convention mandate, MLC mandate, that you must have labor insurance. So they buy that, they consume that. Passenger insurance is also mandated. War insurance is something which is not mandated, but if you are going to the area primarily towards Somalia where piracy is prominent, or you're going to Ukraine or Gaza, it's better that you buy war insurance, but that increases your cost. Maritime Safety Security Agency is another organization which you might need to hire. These are agencies which will give you gunmen. If you are otherwise, guns are not allowed on board the vessel. But if you are hiring a specific security agency, they will give you two gunmen which will take care of your vessel in case of a piracy attack. So again, in Enrica Lexi, if you know the incident where Indian fisherman was killed by the Italian mariners, that was a container ship. And they were providing, these Italian mariners were providing safety on board of the, safety service on board of the Enrica Lexi. Anyways, then another is the Admiralty Law and Dispute Resolution. So when we talk about Admiralty Law, largely it's an in rem litigation. In rem is against the ship itself, where the ship itself become a party. Mostly in shipping law, in cargo claim, you file the case against the shipping line, not the ship itself, the company. But in RAM cases, particularly when the vessel is arrested or when there is a maritime mortgage, you cannot find the owner and you are selling the ship to take all the assets and then pay the money to the seafarers and other mortgagees. So that is in RAM action against the vessel. Primarily, that is what happens in an admiralty litigation. And then another very crucial area is dispute resolution. Maritime dispute resolution, again, when we talk about dispute resolution, we are not just talking about arbitration. It's mediation, conciliation, and arbitration. So you have these three elements very prominent in the charter party agreements in all types of other shipping agreements. You have institutional arbitration. As I told you earlier, you can go to an institute to arbitrate. You can go to GMAC or MIAC or Hyderabad, or you can go to Delhi, Singapore arbitration, Dubai arbitration, Hong Kong arbitration, London arbitration, New York. So you can have you have so many chambers which are available, institutions where you go for institutional arbitration. On the other hand, you also have option of ad hoc. You can have in the agreement that we will formulate an ad hoc arbitration. We will employ arbitrators from our own panel. We will have arbitrators and representatives from our own panel, and we'll have our own ad hoc arbitration for this matter itself. You can do that. So you can have that. You can have fast track arbitration system also at place where you provide a documentary fast course of action in arbitration. So that is also, you don't have to do witnesses, just on the basis of documentation, quickly you come out with a reward. That is something that you can do with the fast track process. And in terms of maritime also, you can have environmental arbitration, environmental maritime arbitration is another issue. You have the Marpol Convention, which provides arbitration. Fund Convention provides arbitration. You have cargo arbitration also, separate arbitration you can set up for cargo claims, sales of ship, right? P&I arbitration, and under the arbitration, your insurance companies will also have a claim. And shipbuilding, shipbreaking, so ship-related arbitrations, again, can be very much there. Some people have worked on dispute resolution also, arbitration also. Again, a very important and very crucial area where the candidates can think about and conduct research, not much people in this area also. At Admiralty, again, we have few people, but I did not find any credible research coming from India on Admiralty. So we can actually, if somebody is looking into this area, they can actually write a good documentation on particularly ship arrest, maritime lien mortgage. And there can be an interblend between the Maritime Mortgage and SARFAESI Act, because there are ships, which gets abandoned and the company has declared insolvency. So in those insolvency issues, what happens to a vessel? And how can you sell the vessel, and who will have the first stake, the second stake, the third stake? How that will happen. So you have a very close linkage of SARFAESI and RDDBFI and banking law with the maritime law also in this regard. So it makes it very crucial, very interesting. Not many people have come out with research in this area, so this can be another way to go. Anyways, you have port infrastructure. This again is crucial. The laws applicable in India in journal for ports is quite outdated. You have the Indian Port Act of 1908. The bill is pending, but the bill is, although it says 2025, but the bill has been pending since last 10 years or so. They have made revision and reintroduced it as 2025. There have been a 2020 bill also. There have been a 2016 bill also. So it's not that latest, but we're hoping that this bill will quickly formulate and come into action, because outdated Port Act of 1908 has a lot of issues. Anyways, so you have the Major Port Act, which is of 2021, which is there, but there are only 12 major ports in the country. So it only operates 12 ports. Rest 200 ports There are around about 210 or 12 ports in the country. So rest 200 ports are governed by Indian Port Act, which again is outdated. So only 12 ports are regulated by the Major Ports Act. So port authorities have to again reshuffle the obligations. Your port conservation is an issue. If you have ever been to a port which is a Sarkari port, a government port, you will find a lot of trash and a lot of not fit code kind of a thing over there. Private ports, on the other hand, are much more cleaner. If you visit the Pipavav port, Jamnagar, so Pipavav port in Hazira, sorry. If you go to the Pipavav port itself, the of APMT, that is a good port, very clean, very nice. Mundra port is one of the cleanest port. So you have these private ports which are running in a much better capability and capacity than the main Sarkari port. Just to give you an idea about it. So they are still up to code with the Marpol Convention and the ISPS code. ISPS code is the International Safety Code for ports, particularly. And they are more in line with the traffic regulations. They have a fixed rate and port services, better fixed rate and port services. With the change on the removal of TAMP, that concession agreements have came into picture. And with private-public partnership, you can actually give them relaxation in tariff. So that again have been a new development in the port sector, port conservation. Anyways, so that and in advance to that, maritime entire hinterland connectivity regulations again are not looked into. When the vessel comes and the cargo is out of the ship, it is coming to your country. Then what are the laws? What documentation the the customs take into consideration? How will the port assess the documentation and regulation of movement of the cargo? How will it enter the Indian subcontinent and the Indian country? So that is something where regulations are not quite there in India. The problem is again with the GST also, because in case of when you are providing services to these ships also which are coming to India, you have to pay GST even if you're giving fuel services, which is not there internationally. So if they are buying fuel from us, they have to pay GST. Outside, they don't have to pay GST, and it is much cheaper. So why will the bunkering industry of India will be successful? So you have a lot of issues in association of taxation and GST implementation and the regulatory restrictions, which unnecessarily delays the cargo movement in the country, which needs to be looked into. The cabotage regulation in the country is another problem, as it restricts or provide additional tariffs on the cargo movement coming from international shipping. So there are certain hurdles. Again, nobody has done research on this area. Absolutely no one. It's a very crucial area. Government is working on it. IFSCA is working on it. Ministry of Shipping, Tax, everyone is working on it. No PhD scholar is working on it. None of them. Anyways, this is another area. Marine environment is a very huge area. Again, private international law, public international law. So under the law of the seas, you will have the public international law subset of it, where you have CBDR, common but differentiated responsibility, polar issues, ITLOS issues, ICJ issues, land-based marine pollution, right? And then you have the private, which is largely associated with shipping. So there are so many different areas in shipping. You can see here. And, I don't have time to come to this, but in shipping, private element, the state who will have the jurisdiction in itself is a big issue. What is the flag state's accountability? What is the port state's accountability? And what is the coastal state? There's a difference between port state and coastal state also. So what are the accountability of these three states? Port state will be a place where your vessel is heading, last, end destination. Coastal state will be where the vessel is passing. For example, if the vessel is coming from Pakistan and going to Sri Lanka, it will go through Indian waters. So in this case, the Pakistan becomes the flagship. Your Pakistani, if it is a Pakistani ship, the Pakistan becomes a flag state. India becomes a coastal state. Sri Lanka becomes the port state. So who will have jurisdiction over what? That is also an issue in case the vessel does a violation. So challenges associated with the maritime law it's too complex. There are topics which are multidisciplinary and associated with technology. Right now, very favorite of many is decarbonization. Many people want to work on decarbonization from ships. This is decarbonization which is in front of you. So in order to have decarbonization, as per the MARPOL Annexure 6, for decarbonization, your vessel should maintain EEDI, which is the Energy Efficiency Design Index. And the below is the formula to calculate EEDI: engine power, specific fuel oil consumption, carbon factor, speed, ship speed. So that's how you calculate. So it's all mechanical, multidisciplinary, science and law, engineering and law, making it a complex venture to enter into. This is the wider formula to calculate EEDI, right? The full formula. The earlier one was a small one. So see how technical it is. Looks like a Sheldon's board from Big Bang Theory, right? So that's the complexity associated with it. Anyways, but as a lawyer, you'll not have to go much deep into this, just understand the basics. And with that, you can actually do research in decarbonization. And decarbonization has many dilemmas in shipping: economics, trade, actually GATS regulations are violated. GATT has to be looked into. WTO will also have a direct implications in decarbonization from shipping. Seafarer rights get accumulated, environmental crimes get opened up, and your seafarers can go to prison for environmental violations for decarbonization policy itself. So and contractual issues. This is not there. Contractual issues, charter party issues erupts because of decarbonization. So it's a multidisciplinary area. Here, maritime delimitation. This is an example of South China Sea. How South China Sea is claiming areas in the Spretter Island. So this is some 9-dash line. This is the 9-dash line, and China is claiming somewhere around 1,000 kilometers of area, nautical miles of area as their own territorial sea, based on their own predictions and availability of these islands. They're putting additional 200 nautical miles because of these islands which are over here, right? So maritime delimitation, not a very easy area. And if you want to look into literature for this area, these are certain places where you can hit and you can actually see the movement of the vessels, and you can basically dig out the research on shipping. But otherwise, very little, there's not much resource on maritime which is available online on different areas, different topics. Um, so, there have been technicalities associated with it. So you have to understand the technical terms if you want to do the research in this area. You have to prepare a proper research proposal, and you have to work on chapterization primarily. But your main aim should be getting through with the publications which are required as per the notification. Anyways, these are a few things that I wanted to talk on. I will stop here as I've already gone past the allotted time. So thank you so much. That's all. If anyone wants to ask anything, any question, I'll be more than happy to look into that and respond to that.
Yeah, thank you very much, Dr. Abhay, for your insightful, I would say explanation on doing PhD in law. Again, we have to understand a lot of things, right? We understand only one term, maritime law, or law of the sea, rightly stated, but a lot of things are there. I would say more than 20 things. I would say I'm just guessing to do PhD in maritime sector. So we will take oral question, then we'll followed by chat box.
Yeah.
Vinod Kumar, you
Sir, thank
can.
you for this. Am I
Yeah,
audible, sir?
Yeah.
yeah, audible, audible. Yeah, you can start your
Thank
video,
you.
audio, video also. Yeah.
Okay, sir, sure. I'm Vinod Kumar Singh, sir, and from Mumbai. And I'm really thankful for this insight. I had a word with you or Dave for yesterday regarding that maritime PhD, which for where I'm very much really interested. But I was really thinking what topic to choose upon. But after listening to this lecture again, I'm confused. So lots of opportunity, delimitations, decarbonization, biodiversity. So how to fix up? Because when we have to write an abstract, thinking of research proposal, to how to come to a conclusion when you give so much ideas. To help me in that, sir.
So primarily, when we talk about maritime law, it's an ocean. It's an ocean of issues. So
So,
you have to look into your interest primarily. What are you interested in? If you are interested in commercial application, or if you're interested in environmental governance, so if you're interested in something else, so or security, maritime security, you have to first shortlist. Sir, you come from broad to narrow. First, you have take a broader perspective. That's how you select a topic, right? You go to a broad
Right.
area. First, you decide, okay, I want to go to environment. I want to go to security. I want to go to the subset or the wider area of whatever governance. Then you come down. If let's say you pick environment, then you come to environment, and then you look into, okay, you have the public international law area of environment, where you have the biodiversity litigation, sorry, the biodiversity issue, the IUU, illegal fishing, illegal unregulated, and this uh, unreported fishing, IUU, or fishing issues, or you want to go to something else, you want to go to seabed mining activity. So that is
Mhm.
one thing you can do. And or you can look into the environment, you want to work on ships. So under ships, if you want to work on, so then you have the MARPOL Convention, you have the six annexures of the MARPOL Convention, right? The annexure on oil, hazardous cargo, Haas cargo. You have the issue on sewage, garbage, plastic, right? There are n number of things, air pollution, and actually decarbonization things come under Annexure 6 of Marpol Convention. That is decarbonization. So that's actually a big convention, small area of that big convention, which is becoming bigger and bigger every single day. So that's one area, sir. So you go with a broad area and you come to narrow. So I did it. I did my PhD on desulfurization, basically. So that was to reduce sulfur emission from vessels, because vessels are the biggest emitters of sulfur. So that was my area, because I thought a problem I actually wanted to do on decarbonization and GSG issue. But what I saw at that time, that shipping doesn't actually emit that much amount of greenhouse gas, only 3%. But the issue is that the why so much concentration is there on decarbonization right now is because it is increasing dramatically, and they are predicting that in next 5 or 10 years it can reach to 10%. So before it happens, they want to bring down the decarbonization. But my area, or what I did, was on desulfurization, which is still the biggest emission thing which is happening from ships. So that's how I picked, sir. I want to do an environment. From environment, I look into desulfurization, and I got enrolled in 2019. And at that time, the sulfur policy had just came out. So it was latest also. So that's why I picked the sulfurization issue. You can take it as per your own interest, sir. You can do it in any topic. You can pick an area, first of all, and then you can go with the guide, and then with the guide, you can think and storm ideas forth and back, and you can narrow down a particular issue. So you go from broader to narrow, sir. That's how you shortlist. I hope that answers.
Yes. Uh, Thank you very much. Any other question, participants? So let me club two, three questions. So what are the research prospect in maritime environment law? What are the various opportunity in this field? And then, yeah, so,
Oh, okay.
and
So
the, yeah,
first
there
of
is a
all,
question.
this if I talk about prospect in maritime environmental law. So if we talk about maritime environmental law, again, we have to look into whether you are going into the law of the sea issue. So in the law of the sea, actually, the data is quite available. You have a lot of research in law of the sea. So you will find on fisheries issues, and FAO is a great agency which works on fisheries issue. So fisheries, biodiversity, delimitation, on all these issues, you will find a lot of material, as internationally there is a lot of research happening in this particular area. Ships, on the other hand, it's unfortunately an area which is not so much ventured into by academia. I don't know why that is, but academic institutions have not so much concentrated internationally. I'm not speaking about India. I'm talking about internationally. There is only a handful of institutions such as Swansea, Tulane in US, Swansea in UK. You have this WMU, which ventured into it a little bit. Uh, my university, which is looking into the private area also. So Internationally, there are not much people who are working into the shipping side. So in that area, the literature is quite less, comparatively less. And shipping is heavily regulated, but still research is less. And there are a lot of complex issues associated with shipping. So that is a very good area and very interesting and very important area which people can actually focus on. And in shipping also, there are so many different issues. Uh, I don't have that much time to directly dive into that and tell you all the issues. Uh, you can do your own research, and if you have any questions later on, you can write to me, and maybe there can be a discussion on that later on. And
Yes,
then,
sure.
yes, sir. Then the next various opportunities in this field, sir. If you're talking about research opportunities, then there are a lot of them. So you have a lot of universities internationally which are looking for faculties in maritime law and postdoc. Right now, also University of this Copenhagen has given a notification. They want somebody for 3 years for postdoc. That also Germany has come out with this very same kind of a thing. So you have a lot of opportunity in terms of postdoc, and then you have think tanks also. In India, you have the National Maritime Foundation. Uh, in Delhi, they are constant need of good researchers. You have the ORF, Ocean Reef. Sorry, ORF is again a very good initiative. Again, a think tank, very powerful think tank on policy and governance of ocean. And you have a lot of United Nations bodies which keep on hiring. You have universities now which have actually started offering research in maritime. We are one of them. We have a lot of actually ministry right now, just recently, Ministry of Earth Science has issued a 45 crores project on on decarbonization from shipping. So again, if you are an academician, look into that earth science project, go for it. So the government is so much emphasis and paying so much money for that purpose, decarbonization. So, you can actually indulge in a great deal of research in this particular area, in this unexplored area primarily.
Sure.
Good evening, sir. I That was my question about the future prospect in maritime environment law. I also wanted to know what like job prospects in India itself, not abroad.
So that's what I was talking about. Job prospect. You have the Maritime National Foundation, National Maritime Foundation, NMF, ORF, and academic institutions who do research in this area. We are one of them. All the national law universities now are catering to that. NALSAR is also working actively in maritime. NALSAR has just done an MOU with DG. We did the MOU with DG just 2 weeks back, and then NALSAR copied us and did the MOU with DG itself also just today. So DG is Director General of Shipping. So you have a lot of academic institutions. Mumbai National Law University, again, Nagpur National Law University. So you have a lot of national law universities who are venturing into this area. Again, Tamil Nadu Ambedkar Law University School of Excellence is another institution which is pushing maritime law. They have an LLM and they have a Center for Maritime Law also. So there are a lot of research, teaching, and opportunity in maritime academia per se, if you pursue PhD in maritime law. Right.
Sure.
Okay, sir. Thank you, sir.
Yeah, I think we are done with all the questions. So thank you very much, Dr. Abhay, so for your insightful talk and then explanation. I hope and then participant, prospective scholar would have got some insight which topic you should go on, and then definitely, you rightly stated you have to narrow down because and then this again it's an unexplored area. Many things are there in maritime law. So on behalf of Law Teachers India, we are grateful for your sparing a wonderful time and your great insight on this topic. So thank you very much and look forward to see you in future events also. Thank you.
Thank you so much, sir. Thank
Thank
you.
you. So thank you participant for joining and see you in the next edition. Thank you.